All right, good afternoon, everyone. Let's begin. This is the State Expedited Accusations calendar. This calendar is for those individuals who've been recently arrested with the cases have already been formally accused and bound over to state court. All defendants, you have an absolute right to remain. Anything you say regarding the facts of your case can and will be used against you. You also have the right to an attorney at this particular proceeding as well. Those who receive a surety bond, where will they be reset? Can I have my reset date, please? Ms. Grace?
Yes, Judge. Write it on my
Good
tab.
afternoon. What is my state of reset date?
June the 6th.
All right. Those who receive a surety or cash bond will be reset to state all purpose June 6th. Those who receive a signature bond, whether through the jail or pre-trial, will be reset for the notice. Have all defense attorneys had the opportunity to speak with their clients and interview their clients so that we can proceed?
Yes, Your Honor, I have.
Yes, Your
All
Honor.
right. Wonderful. All right. Who do we have first?
Good afternoon, Your Honor. Position 19, Ms. Sharma.
All right. And is the camera on at ACDC?
She's nodding her head, Judge.
All right. Okay, I see her now. It wasn't on at first. All right, Ms. Sharma, your case is 23 CR 003285G. In this case, you're charged with DUI, that's safe driving with defective or no headlights, unsafe vehicle equipment while in open container with the offense date of May the 22nd. Do you understand your rights today?
Yes, ma'am.
All right. Mr. Howard, are you present? Can I have the history, please?
First arrest.
Thank you. All right. Ms. Bickerstaff, if you please proceed.
Yes, Your Honor. Hold on 1 second. My computer is frozen on here. Okay, Your Honor, so this incident occurred on May 22nd, 2023 on Scott Road and Celebration Drive in Roswell. And this is where officers observed the defendant driving a car with a flat tire. And when officers approached the defendant, they noted the smell of alcohol. The officer informed the defendant that her headlight was out and that she had a flat tire, and where the defendant stated that she hit a curve and she figured that she could make it home. The defendant did admit to having a margarita earlier, and while the defendant's car was in inventory, a half bottle of Tito's vodka, an empty beer can, a spiked lemonade, and a cup of alcohol were found in the car. For these reasons, Your Honor, the state's recommendation is a $2,000. Sorry, it's frozen again. I'm sorry. I'm so sorry. I don't know what's going on with my laptop. Oh, yes, it's a $2,000 surety bond. No, I'm sorry, $2,500 surety bond. $2,000 for the DUI, $500 for the defective headlight, $500 for the unsafe vehicle equipment, and $1,000 for the possession of open container, as well as no driving without DDS approval, and no alcohol, drugs, or weapons while out on bond.
Okay, I'm sorry. So that should be 3,500.
3,500. I'm sorry, with bad math.
Okay, thank you. Who represents this defendant?
Alvin Shah, Your Honor, on behalf of Ms. Sharma.
All right, Mr. Shah, please proceed with your recommendation.
Thank you, Your Honor. Your Honor, first of all, I'd like to begin with objecting to everything that the state just argued. She indicated that for these reasons, she's asking for a $3,500 good bond. And I would contest, Judge, that all the reasons that have been stated are arguably under IALA. Nothing that applies as far as the IALA factors go. We heard nothing from the state whatsoever with regard to Ms. Sharma being a flight risk, her being a danger to the community, that she was not going to intimidate witnesses and that sort of stuff, Judge. With regard to those factors, Your Honor, I'd contest, Judge, that she has so many ties to the state. She's a graduate of UGA college. She had a 3.9 GPA, Judge. She graduated from Management Information Systems and Biology. She graduated from Alpharetta High School with a 3.9 GPA with a Zell Miller Scholarship. She has her mother present, Miss Minnie Sherm. If you'll just wave your hand for the court. So she's here, Judge, for her daughter. She lives with her daughter, and Ms. Sharma also, we have an address that we can provide to the pretrial services judge, and she'll be residing there. She's been living there since 2015, and she's been living in Georgia her entire life, but she's been living with her mother at this particular address that we can type into the chat box, Judge, and she's been living at that address since 2015. She had an internship, Judge, with Assurant, and while she was in college, and now they've offered her a full-time permanent position with that company. She also volunteers with her grandparents at Meals on Wheels and various other hospices that are local to where she lives. And she also volunteers with her school and teaches meditation to students that have mental health issues. As you heard, Judge, she has no prior criminal history whatsoever. She does have some serious medical conditions, Judge. She has, and I got permission from her to talk about this in a public forum, but she has ulcerative colitis, and I know I'm butchering that medical terminology, but it's an autoimmune gastro
Where, yeah,
intestinal disease,
let's
Judge.
not put too much of that on the record, even though she's given permission. But I think I'm
gotcha.
the nature of
Well, but the purpose of me bringing that up, Judge, was she's indicated to me that she's scared to eat anything at the jail, not to complicate that condition. And for all of those reasons, which actually do fit into the ILA factors, Judge, I'm asking Your Honor to post or to issue a $3,500 signature bond for this student who's barely working right now and can't afford a $3,500 good bond.
All right. In light of the information before me, the defendant is going to receive a $2,500 split bond, and it will be broken down as follows: $1,000 good on the DUI, $500 good on the open container, and the defective driving and the unsafe equipment will each be $500 signature bonds through the jail. So that should be 1,000 SOB through the jail and 1,500 that she'll need to make good bonds on. She is not a drive unless she has permission from the Georgia DDS, either through a valid license or a permit. Additionally, she's to have absolutely no alcohol, drugs, or weapons during the pendency as a condition of this bond. Is there
Understood,
anything
Your Honor.
further?
Not from the defense, Judge.
All right, Mr. Shaw, does that conclude your business today?
It does, Your Honor, if I may be excused.
Yes, you may. Take care. Have a good day.
Thank you, Judge. You as well.
All right, best of luck to you, ma'am. That's the end of your hearing. Are we able to take position 5 that belongs to Mr. Dixon?
Yes, he's in here.
Okay.
Mr. Carr?
Oh, that's why we probably have to take it to the end, unfortunately. I just read the charge. Okay, Mr. Dixon, I did try, but we can't take your client right now. We'll elaborate on that shortly.
Oh,
Right.
okay.
Can we go to a different position, please?
Yeah. Position 13, Ms. McCray. She also has a visitor in the gallery. Is that your mother?
Okay. Ms. McCray, your case 23 CR 003280G. You're charged with battery family violence with the offense date of December the 12th of 2019. Do you understand your rights today? All right, Mr. Howard, can I have her history, please?
What number is this?
13.
Oh, Oliphant. Hold on. First arrest.
Okay, thank you. Ms. Bickerstaff?
Yes, Your Honor. So this incident occurred December 12th, 2019 at 5071 Upper Elm Street. And this is where officers arrived regarding a dispute and met with Miss, I'm sorry if I mispronounced this name, but Raisha Opalfont, and that's spelled Raeisha. Last name is Olipant. So officers met with Miss Raisha, who stated that her wife, the defendant, became irate when she suggested a way to file their divorce. And that made the defendant very upset. And so when Miss Raisha tried to separate herself, the defendant began yelling and shouting at her. And then she grabs a wax warmer and threw it at her, which hit her and caused a laceration to her forearm. Then when Miss Raisha went downstairs, the defendant continued to throw things in the house, including chairs. For these reasons, the state's recommendation is a $3,000 surety bond, 1-day anger awareness course, no further contact with Miss Raisha Olifant, to stay away from the 5071 Upper Elm Street address, as well as no alcohol, drugs, or weapons while out on bond.
Is Miss Raisha Oliphant present and wishes to make a statement? Is that who's at the gallery?
I'm here, Judge.
All right, if you wish to make a statement, I'll need you to raise your right hand so I can place you under oath. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes, I do.
All right, I'm not imposing any sentences or anything of that nature today. What the facts and what you disagree with what the state said is not what's particularly important to me or what I need to hear. What I'm most concerned is whether you wish to have contact with the defendant and whether you have any concerns for your safety. With those instructions, what would you like to tell me today?
I do not have any concerns with Katoya or my safety at all. I did not know that this was occurring and hope that they're dropped.
Okay, thank you. I appreciate you making that statement. Mr. White, is this your client?
It is, Your Honor.
All right, please proceed.
Judge, I think I can save the court a lot of time. I was trying to butt in, but I was muted. I apologize. This case has not been indicted within the statute of limitations. Even if you add on the tolling of 109 days for the of the year and 109 days because of COVID, March 31st would have been the deadline to accuse this case.
Okay, hold on.
So we're asking to be dismissed on statute of limitations basis.
And your response to that, Ms. Biggerstaff? Or Mr. Walker?
No, that is correct. It does look like that is correct.
I'm looking, so I believe that's correct as well.
Yeah.
I'm doing the math myself.
Too.
I'm looking as well, Your Honor.
Yeah, math is not my strong point, but I'm doing the calculation.
It's 474 days added onto the 2 years, so that would get us to 331.23, give or take a day or two, but
Okay.
definitely within or outside of the statute.
Well, I would say this: if the defendant is unavailable to prosecute, I believe there's certain situations that the statute would toll. So we obviously ask that the case is not dismissed as right now. Perhaps we could discuss a signature bond or a reduced bond, but I think it will be proper.
I think that's what we're gonna do. We're gonna give her a signature bond, because I understand your position at this point, Mr. White. What we'll do is I'm gonna give her a signature bond through the jail in light of that information, with no conditions other than no further violent contact with the victim. And we're gonna figure this out either at an SAP calendar or at a later date. I understand, Mr. White, your concerns, but I just want to.
If I could address Mr. Walker's, her availability has no bearing whatsoever on whether or not they can accuse the case, just like they've accused every case this morning, with or without the appearance. It's not like they needed to impanel. They can directly accuse any case they want. They've had 3.5 years to do so.
Understood. I'm gonna still give her that signature bond. We'll figure it out at a later date, all right? So she has a signature bond through the jail,
What's
3,000 SOB through the jail, no further violent contact with the alleged victim. And those will be the only conditions, all right? And I implore the state and defense to have further discussions regarding the SOL, even though I am inclined to agree with Mr. White's position at this time. All right, ma'am, best of luck to you, where you'll be able to sign your own bond and get out today. Well, they'll begin processing you out, let's say that, okay? Best of luck to you. All right, who do we have next?
Next case is position 6, is a private attorney, wanted to know if they're on the Zoom. Elm,
What's the name of the attorney? Does anybody know?
I'm saying the position, Andre Elm, position.
Right,
That's
but-
Elam.
Right,
Elam.
but you're asking if his attorney was on the Zoom? I was
Yes.
asking if we knew the name of the.
I don't know the name. Do you know the name of your attorney? Elam, where's Elam? Katrina Hines?
No, there's no Miss Hines that I see on this Zoom.
Okay, I'll move on to the next.
He has another open case in Superior Court, so I don't know if that's his attorney for that matter.
You may not be aware of this proceeding
That's,
today.
I mean, that's my guess.
Position 2, Bolton.
All right, Mr. Bolton, I'm sorry, Miss Bolton, I apologize. Your case is 23 CR 003269F. In this case, you're charged with simple battery family violence with the offense date of April the 19th. Do you understand your rights?
Yes, ma'am.
Mr. Howard, can I have the history, please?
13 total. Last arrest was 2017 probation. As far as violence, I see a 2010 assault and battery conviction, 2009 battery conviction. A lot of probation violations there.
Okay, thank you. Mr. Walker?
Yes, in this matter, Your Honor, the defendant and the victim was in an argument pertaining to food and money. At that time, the defendant did become physically aggressive. She grabbed the victim and pushed her into the sofa. Her name is Miss Janisa Ware, I believe. The incident location is 1026 Collier Road. We will be asking for a $2,000 surety bond, no further contact with the victim, and to stay away from the incident location. And Miss Ware is on the line.
Okay, Ms. Ware, if you'd like to make a statement, please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes.
All right, and again, same instructions. I'm not imposing any sentences today, so what you might disagree with that the state just presented is not of the most importance. What's critically important to me is whether you are in fear of the defendant and whether you wish to have any contact. In light of those questions and statements, what would you like to tell me at this time?
She don't, since the incident was a month ago. We haven't spoken. All I wanted was the police to help get her stuff, to be there while she got her stuff. She removed her stuff from my premises. We haven't spoken. Like, I'm in therapy. This just dredged up what I've been trying to get over. It's been done. Like, so this is just, it's more trauma to me than it is to her right now, bringing this back up. But
All right, so
she hasn't spoken. She don't bother me. I'm not in fear of nobody. I'm not in fear of her. She don't bother me. She don't come around. I haven't spoken to her in over a month.
So I'm assuming you wish to have no contact. Would
I
that be?
mean, we don't contact each other anyway. That don't matter. Like, you don't have to tell her don't contact me. We don't contact each other anyway. It hasn't been no further incident. It's just, it was a relationship. The relationship ended. We both moved on.
Okay, I understand. Thank you. Ms. Wills, please proceed.
My client she is originally from Georgia. She is currently employed by both 1-800-Flowers, and she recently began a new job at Truist Park. She does have a high school, she does have her GED. She has one 16-year-old son. She states that she was formerly in a relationship with Miss Ware. She was unaware of this incident. As Miss Ware stated herself, she intended to have law enforcement assistance for Ms. Bolton retrieving her property from the premises. The actual incident of someone being pushed or Ms. Ware being pushed onto a sofa is somewhat suspect. My client denies all of the allegations. She states that she did not make physical contact with Ms. Ware, that this police report was likely the result of some sort of revenge after my client no longer wanted to be in a relationship with Ms. Ware and began a relationship with someone else. My client has no desire to have any further contact with Ms. Ware. She actually intends to file a TPO. She states Ms. Ware has come to her home, left her AirPods in her car to track her whereabouts, and busted out the windows in her vehicle. So my client is fearful of Ms. Ware at this time, again, desires to have no further contact and will be making her own police report. For all of those reasons, I would ask for a signature on bond. My client, her last arrest was 2017. Her last assault or anything violent was over 13 years ago. And again, based on Ms. Ware's statements herself, it wasn't her intent to file an incident report. It was just to have assistance with Ms. Bolton gathering her belongings.
All right, thank you. Defendant will receive $1,000 surety bond. She said have no contact with Ms. Ware and stay away from that incident location. Additionally, she said have no drugs, alcohol, or weapons as a condition. Is there anything further?
No, Your Honor.
All right, best of luck to you, Ms. Bolton. Who do we have next?
Position 10, James.
Hey, how much was that?
1,000.
1,000.
Yes. All right, good afternoon, Mr. James. Your case is 23 CR 00328 In this case, you're charged with simple battery with the offense date of December the 10th of 2022. Do you understand your rights?
Yes, ma'am.
All right, thank you, Mr. Howard.
Oh, I don't have a James. He wasn't on my pool sheet.
Okay, we'll go to Mr. Walker. If you could give me the history as well,
Okay, 1 second.
if you have it.
I have it. I just, one moment, I can see what's going on with this history. I'm showing out of state charges, I believe North Carolina, however, it's drug charges, so checking to see for anything violent. It's primarily drug charges, but with that being said, this case is about the defendant and the victim were in an argument again over food and food stamps. At the time, the defendant became violent. He did punch and slap the victim, whose name is LaTanya Walker. I believe this happened at his apartment, but we will be asking for no further contact with the victim and a $1,500 surety bond to the 1 count simple battery.
Ms. Wills?
My client has resided in the state of Georgia since 2007. This incident did occur at his residence. He lives there along with his uncle, Mr. Lazenby. He does qualify to be represented by the public defender's office. My client states that, well, he denies the allegations as alleged. He states that on the date of the incident, which was back in December 10th of 2022, that the alleged victim or complaining witness came over to their home. There was a verbal disagreement at that time because the complaining witness was becoming upset and irate. Both my client and his uncle asked for her to leave. She continued to become upset. At some point, she became intoxicated, came back to the home because she had left her phone. She gave her phone, or they gave her phone to the complaining witness. And that was it. There was no physical altercation. The facts that were alleged were that both my client and his uncle essentially jumped this woman, but there were no marks or bruises noted on or about her person. For all of those reasons, I would ask for a signature on bond. If your honor is not so inclined, I would ask for a $500 surety bond. My client has not had any contact with the complaining witness since this date, and she is a friend of a friend, so he has no direct relation or connection to her.
All right, defendant will receive $1,000 surety bond. He's to have no contact with the alleged victim. Additionally, he's to have no drugs, alcohol, or weapons. Anything further? All right, best of luck to you, sir. What do we have next?
Oh, quick announcement. Did you guys want to do position 5 and just waive sound since they have a private attorney?
We can do it, but this thing won't be waiving anything.
No, the state will read the whole thing, so we have to do it in.
Position 18, Scott.
All right, Mr. Scott, your case is 23 CR 003284D. In this case, you're charged with battery, family violence, and criminal trespass, damage to property with the offense date of August the 28th of 2021. Do you understand your rights?
No.
All right, Mr. Howard.
This is the 9th arrest. Last was May 2022. Possession of a firearm by a convicted felon or felony first offender. Possession of mail theft by receiving, possession of drug-related objects, possession of a Schedule 1 or 2 controlled substance with intent. Possession of a knife or a firearm during the commission, giving false names, false statements, and concealing facts or fraudulent documents in matters of government. I got to open shoplifting in Superior Court, 22 CP. Yeah, they put too many numbers on there. He's on probation for that case I just listed with all those charges out of Floyd County. They gave him 15 years probation, November 2022.
Okay. Thank you. Ms. Vickers?
Yes, so this incident occurred August 28th, 2021 at 493 Boulevard, apartment or unit 101. And this is where officers arrived in response to the defendant grabbing Miss Stevetta Reese, that's STEVETTA Reese, Miss Reese's hair, and slamming her head into the wall, and he then slapped her in the face. Officers noted that Miss Reese sustained a scratch on her lower forearm from the attack. The defendant then kicked in the entry door to the apartment, damaging the door. For these reasons, the state's recommendation is a $3,000 surety bond, 1-day anger awareness, no further contact with Ms. Reese, and to stay away from the 493 Boulevard, Unit 101 address, as well as no alcohol, drugs, or weapons while out on bond.
Is Ms. Reese present? I want you to make a statement. All right, hearing none, Mr. White. If you're speaking, you're muted.
Sorry, Judge. It's been a long time since I've done a Zoom court. So this case is August of 21. So it's over a year and a half at this point. He's been incarcerated now for the last year, various jurisdictions. So he has no income whatsoever. He is not going to be released anytime soon. So we would just ask that he be allowed to sign his own bond in this case, considering the age of the case. And if not a signature bond, then $1,000 each count.
All right. At this time, defendant will receive a $2,000 surety bond, $1,000 each count. He's to have no contact with the alleged victim and stay away from that location. Additionally, he's to have no drugs, alcohol, or weapons. Anything further? All right, best of luck to you, Mr. Scott. What do we have next?
Position 11, Mincy.
All right, Mr. Mincy. Your case is 23 CR 003288D. In this case, you're charged with DUI, less safe, and possession of open container with the offense date of February the 26th. Do you understand, right?
Yes.
All right, Ms. Bickerstaff, I'll just defer to you for the history.
I have that this defendant has 7 arrests here in Georgia. I have an open case, which is 23 CR 002972D for reckless driving, reckless conduct, willful obstruction, and driving, fleeing, and eluding. And in that case, there was a $2,500.
I said that bond. What was the date of that? Is that the same incident as this? That was my question. No,
No, let me just make sure. Let me go back to the.
I just want to know what the incident date was
I
for
thought
that.
this was terrorist and threats. So it's driving?
No, this is DUI.
DUI?
Mm-hmm.
1 second, Your Honor.
I don't know if it was the same day as his reckless fleeing and eluding.
I don't believe so, but
Let me pull the ones.
What's the date on this? This date for this order, for this bond order was May 16th, 2023. Let me see the date of the incident though. One second.
And I'm also assuming he didn't make bond on he didn't make the $2,500 bond set on the 16th, I'm assuming.
Let me look at that too. So the date for this incident was January 7th of this year.
Okay, so it's not the same date.
Yes,
Okay. Okay, that was what I wanted to know. All right, please continue, Ms. Bickerstaff. Thank you.
Yes, so this incident occurred February 26, 2023, and this is at West Side Way. And this is where officers observed the defendant driving at a high rate of speed. And the officer noted that he had to drive out of the way because the defendant was coming at him and the road they were on was a dead end. And so when the officer stopped the defendant, the officer noticed the open container of alcohol near his driver's seat. And the officer also noted the smell of alcohol on the defendant's breath. Considering the open case that had a $2,500 surety bond, as well as no driving unless valid license, the state's recommendation for this case is a $2,500 cash bond, $1,500 for the DUI and $1,000 for the open container. Again, no driving unless without DDS approval, and no alcohol, drugs, or weapons while out on bond.
Okay, and he didn't make the $2,500 from the 16th, or he was rearrested subsequently? That's my question. Does anyone know?
I believe he's been in jail.
The entire time?
Yes, sir.
Okay, that was my question. All right, Mr. White, please proceed.
And Judge, you'll have to bear with me. When I first talked to Mr. Mincy, I had no paperwork, no idea really what was going on. And I'd received an early email that a couple of charges were NOD'd. So that's all I knew. So it looks like I do have an incident report from the 26th. We'd asked that he be allowed to sign his own bond. He actually has been in jail this amount of time, unable to make bond. So additionally, he's charged with less safe. So I know of no fields, no breath, no real evidence that the state has as far as DUI goes. So we would ask that he be allowed to sign his own bond. Again, I apologize. I didn't have a lot of information to go on. And I don't see any warrants either. I'm sure there are some warrants somewhere, but I haven't been provided with any warrants.
Okay. Ms. Grace or Ms. Champion, is it possible for this case to be set? Can he Can this case as well go to SAP for his original SAP date? Is that possible? Do we know?
Original SAP date, Judge, what, you have
Yeah.
another,
He has a
There's
SAP.
another case, it's May 30th for
Can,
that.
can this case be set on the May 30th so all his cases can be addressed at once?
Yes,
Hopefully.
ma'am.
Thank you. All right. Defendant will receive a $1,500 surety bond broken down 1,000 count 1, 500 count 2. He's not to drive unless he has a license issued by the Georgia DDS. Additionally, he's to have no drugs, alcohol, or weapons, and he will be reset to the May 30th state of purpose calendar.
Judge, so I guess I'm confused. How come he didn't have a first appearance when he was initially arrested in February? So it's a DUI charge. I'm sure that he would have been arrested. And
I'm assuming, and I'll let Ms. Bickerstaff and Mr. Walker speak to this. I'm assuming that this charge appeared at some point during his incarceration since the arrest on the 16th. That's my assumption. Is that what happened, Ms. Bickerstaff? Do we know?
I'm not sure, Your Honor.
That's why I asked if it was the same incident date.
right. Did
So
he? Do we know if he made bond on the, because
he
I
said
think
he did not. So he didn't
Well,
make bond on the cases on the 16th is what I'm heard.
I'm referring to the 26th because the case that we're here about, if he was arrested, he would have had to have made bond.
That's a good point. Yeah.
That
I don't
case.
know that. Was he arrested subsequently then? Do we know?
So, Judge, it looks like he was being released yesterday and they rebooked him back into the jail. The jail screen said he was being transferred to another agency and they rebooked him on 5/23 for these charges. They
So
were
these charges popped up. There was no
right. It was a bind over case from Alpharetta, I think.
Okay, so I guess Alpharetta didn't keep him then. So he didn't. Did he serve? Does anybody know if he served time at the Alpharetta jail on this?
I have no clue, Judge. So the jail screen just said he was transferred to another agency on 5/23, and then they rebooked him back in on 5/23. So I don't know if they transferred him to Alpharetta for these warrants, and then Alpharetta brought him right back.
Alpharetta brought him back.
But when they brought him back over here, they didn't assign a bond to those charges. That's why we put him on the SCA calendar.
Judge, I mean, this sounds more and more like a Riverside issue to me, and I know he's got other things holding him, but it doesn't make a lot of sense. That I think it's unlikely.
I'm sorry to cut you off, but I'm looking into it. It looks like he was arrested maybe on a bench warrant on this case out of Alpharetta.
A bench warrant from a February 26th case? That doesn't make a lot
I'm
of
just
sense.
saying what's in the paperwork.
Okay,
And
hold on.
That's not even a month ago.
That's a bind. It's a bind over.
It's a bind over case,
Correct.
so that wouldn't necessarily have been handled the same. I don't believe I see a Riverside issue here because it doesn't look like he would have served more than that time on these two charges. Is what
I think he's
I'm
been in
looking.
jail at least since the 16th and hasn't had a hearing on this case. That's more than 72 hours.
Right, but if he wasn't on this particular charge, the 72 hours had not yet begun to tick. That's what I'm trying to see. Okay, let's look.
When was it bound over?
I don't know, but it says the bench warrant was issued 5/18.
Okay.
So I don't believe it's a
So he's
Riverside issue.
been in custody since then.
I don't believe it's Riverside. Let me look. Hold on. Did he make bond on the charges from the 16th?
And
Is that why he
furthermore,
was-
I'm reading the report. I'm sorry, all this is happening live time, but it doesn't even like he was arrested. It says he was released on a copy of the charges. Now that
Oh,
I'm
wait,
reading the report.
one second. Ms. McLeod, didn't you represent him at the last hearing because the public defender's office was conflicted?
Yes, Your Honor, that is correct.
Oh, so Mr. White, you can't even properly represent him. I believe Ms. McLeod has to, but the same issues. We still got to figure this out. So
And he
I
was
don't think.
released on a copy of the charges, and looks like he bench warrant or he had a court date out at Alpharetta on 5/18. So no, it's not a Riverside because he was never arrested.
He was here, so he couldn't make his court appearance, which is
I'm aware of how that works, but I was just I was answering the initial question: was he arrested back in February? And no.
And the answer is
fair
no.
enough. But the bench warrant was assigned on the 18th because he was incarcerated here, Judge. So that's a valid excuse for him to miss court.
But this is not the
That's
court that
what you
issued the
understand.
bench warrant. Like,
Sorry?
I hear the issue, but I'm not hearing Riverside is the thing.
Okay, Judge, my argument has changed from Riverside in light of the new information provided by the state. The bench warrant was issued on the 18th because he missed a court date that day, which he was incarcerated here in Fulton County, so he could not have possibly made his court date. That's a valid excuse for not appearing in court.
I understand that, but I didn't issue the bench warrant. Let me think about it. Okay, go ahead, Mr. White.
Do we want to let Ms. McLeod represent him since it's a conflict, or?
Right, technically, Ms. McLeod has to do it. Mr. White, but I mean, Mr. White's making valid arguments. I'm not shutting him down, but technically, Ms. McLeod is the one who should be speaking right now.
I had no idea that he was a conflict.
And
neither did I. I have not spoken to him about this issue or anything.
Ms. McLeod, do you want to speak with him briefly? Just because it's properly, he is your client. And I remember you represented him on the 6th.
Yes, yes, Your Honor. When his name was called, I thought it was familiar, and I said, I didn't realize it was him.
I remember now that there was a conflict. Okay, Mr. White, we're going to table your arguments. I believe that they are valid, and I'm going to consider them. But technically, Ms. McLeod does represent him and has to speak with him so that she can conduct the hearing today, because the public defender's office has a conflict. All right, this has been a fun day. Please hold. Can Ms. McLeod give the jail a call, please?
Yes, Your Honor.
Number she can call.
Your Honor, I was going to check in on my position, Sydney Carr.
Right, I understand. I know you're here. I see you, but the state's position for our cases regarding that charge is that they're going to discuss the entire thing on the record without a breakout. There have been lots of robust discussions about that, and I'm trying to preserve some safety issues by addressing that case last. Okay.
Thank you, Your Honor.
Thank you, and I appreciate Mr. Dixon you checking in. Who do we have next? We'll come back to Mr. Mincy.
Position 17, Purnell.
Mr. Purnell, your case is 23 CR 3283F. You're charged with criminal trespass. Do you understand your rights? All right, Mr. Hart, can I have the history?
84. Last arrest was February, probation. He's on probation for shoplifting out of Superior Court. That's all I typed. I didn't go any further.
Okay, that's fine. Ms. Bickerstaff?
Yes, Your Honor. This incident occurred yesterday at the Starbucks located at 867 Peachtree Street. And this is just where the defendant remained at the Starbucks after being told to leave by the security guard and then officer. So the state's recommendation is a $1,000 SOB through pretrial services and to stay away from the Starbucks at 867 Peachtree Street, as well as no alcohol, drugs, or weapons.
I'm inclined to send that SOB through the jail, Mr. White. Do you have any objection to a signature bond through the jail with a stay away from the Starbucks?
None whatsoever, Judge.
Okay, so Mr. Purnell, don't go back to that Starbucks, but otherwise I'm allowing you to sign your own bond, all right? Okay. All right, take care, have a good day.
What was his bond? I had stepped away.
SOB signature bond through the jail.
$1,000.
Thank you. Okay, good job. Position 18, I'm sorry, position 15, Peloton.
All right, let's see, Mr. Peloton, are you present? Your case is 23 CR 003281E. You're charged with criminal trespass with the offense date of the 23rd of May. You understand your rights?
I do, Your Honor.
All right, Mr. Howard.
6 total. Last was 2017 probation. It says he got an open case out of Fulton, domestic animal livestock at large and nuisance. 3 probation violations, 2 from 2016, 1 from 2017, and a 2015 possession of a Schedule 4 conviction.
Okay. Thank you. All right, Ms. Dickinson?
Yes, Your Honor, this incident occurred yesterday at 1443 Richland Road. And this is where the defendant, without permission, was seen on video walking on Mr. Dewin Pales, that's Dewein Pale, Pelle, Mr. Pell's property, and he was throwing sticks on his backyard or in his backyard. And our office was able to speak with Mr. Pell today, and he said that the defendant has been told to stay away from his property, so he installed cameras around his home. And on this day, he was alerted that the defendant was in his backyard throwing sticks. Mr. Pell let us know that he would like no contact with the defendant, and he would like for him to stay away from his home. And so for these reasons, the state's recommendation is a $1,000 surety bond, and no further contact with Mr. Dewin Pell, and to stay away from 1443 Richland Road, as well as no alcohol, drugs, or weapons while out on bond. I believe Mr. Pell is on the Zoom call, so I would like to sound for him.
Mr. Pell, I see you. If you'd like to speak, please turn on your camera, raise your right hand. Do you swear and affirm testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes.
Again, I'm not sentencing anyone today. Whatever you might disagree with, that's not of importance and relevance. The most relevant thing is your position regarding contact. What would you like to tell me today, Mr. Pell?
Essentially, I would just have no interest in this person coming near my property or contacting me. He's made violent threats against me and has continued to not understand the bounds of our property. And because of that, I don't feel safe in his presence. So I would wish that he would not have any sort of contact with me or come near my property in the future.
All right, Mr. Pell, thank you for coming to court and making that statement. Mr. White?
Judge, they're neighbors, their property's abut. And so close that they basically share a driveway is my understanding. Mr. Peltonen was actually getting rid of some refuse, walking down what he thought was his property, but it looks basically on the line, and the sticks was refuse that he was emptying into woods that abut both pieces of property. He wasn't intentionally in the other person's yard. He doesn't want any drama at all either. I've explained to him that he needs to be careful to make sure that he just, whatever he's doing, not cross over in the neighbor's yard. But as far as contact or stayaways, I mean, they're next door neighbors. So we would ask that he be allowed to sign his own bond in this charge. He does not qualify for our services going forward. He's recently married, and both he and his wife are employed. And it's been over 6 years since his last arrest. So he'd ask to be allowed to sign his own bond.
Just briefly, Your Honor, with speaking to Mr. Pell today, with the open case and the defendant trespassing on his land, it's not just him coming on to his land and throwing the sticks. The defendant has like farm animals such as pigs that have bit Mr. Pell before and gotten in his yard. So it's not that he just doesn't want him to trespass. It's like he has animals that are coming over there. He saw on his camera, Your Honor, that the defendant was in his yard throwing sticks. So that is why the state's recommendation is a $1,000 surety bond, no further contact, and to stay away from his property at 1443 Richland Road.
Okay. Defendant's going to receive a $3,000 SOB through the jail. He is to absolutely stay away from Mr. Pell. Don't even look at him, Mr. Pelton. I understand he's your neighbor, but if you see him, you turn around, you go the other way. Additionally,
Your Honor.
Do not cross the line onto his yard. Do not bother that gentleman. Do you understand that?
I do, and the pigs no longer live on the property.
Don't say anything else. Just tell me.
Hey, what did I tell you before we started?
Don't say anything else. You're not gonna look at him. You're just gonna go the other way, and you're not gonna speak to him, and you're not gonna cross the boundaries of your yard. You're gonna stay on your own property. Okay?
Okay, Your Honor.
All right. Best of luck to you. Good luck, and to Mr. Pell as well. All right. Who do we have next?
Position 14, Owens.
All right. Good afternoon, Mr. Owens. Your case is 23 CR 003279Y. In this case, you're charged with 2 counts of simple battery family violence. You understand your rights? Was that a yes?
I said yes.
Thank you. Mr. Howard, can I have history, please?
First arrest.
All right. Ms. Bickerstaff.
Yes, so this incident occurred yesterday at 755 McDaniel Street. And this is where officers spoke with Miss Samantha Owens, the defendant's grandma, who advised that the defendant purposely bumped into his uncle, Mr. Jamario Owens, for no reason. Miss Owens, her first name Samantha, stepped in between Mr. Owens and the defendant to prevent a fight, and that is when the defendant pushed his grandma from behind, causing her to fall and injure her knee. When officers spoke with Mr. Owens, he advised that he had just came home from work and the defendant purposely bumped him with his shoulder. And so when Mr. Owens asked the defendant, what are you doing? The defendant replied, what are you gonna do about it? For these reasons, the state's recommendation is a $6,000 surety bond, $3,000 on each count, to have no further contact with his grandma or uncle, Samantha Owens and Jamario Owens, 1-day anger awareness course, and to stay away from 755 McDaniel Street, as well as no alcohol, drugs, or weapons while out on bond. And if Mr. or Mrs. Owens is on the Zoom call, I'd like to sound for them.
All right. Are either Mr. Owens or Ms. Owens present? Hearing none, Mr. White, please proceed.
Your Honor, this is Mr. Owens' first arrest. He is 18 years old. He also denies vehemently the allegations. He says that it did not happen at all. So we're asking to be allowed to sign his own bonds. This is his first ever arrest. He is in the process of searching for a job. He knows that he understands that he's not going to be able to go back to the place while the case is pending. I explained that to him. He's already going to have a tough enough time trying to come up with a place to stay. And so he obviously does not have the money to make bonds. So we're asking that he be allowed to sign his own bond.
All right. He's 18.
Yes, Judge, as of February 21st, I believe is what.
He's gonna have to, with Mr. Howard, does he have to have a cosigner if he's 18?
Yes.
He does. Mr. White, is there anyone who could co-sign for him if I give him a signature bond through pretrial, as I'm inclined to do?
We'd need to ask him. I think he's an adult. He could be charged as an adult if he was a year younger even. And
right, I understand, but pretrial makes these rules, and that's one of the benefits of being able to go through pretrial. They require him to have a co-signer. Mr. Owens, is there anybody that an adult over the age of 25 who can co-sign your signature bond if I give you one? That's not your grandma or your uncle?
Yeah, my mama, I just don't got her number.
Okay. That's problematic as well. I would like the defendant to have an SOB through pretrial, 3,000, 1,500 each count, to take the 1-day anger awareness course and to have no contact with either of the victims. Stay away from that location. However, if he has no one to co-sign, Mr. Howard, is there some way that I can waive that requirement or no?
You can do whatever you choose.
Okay.
I mean, it's per judge.
It's per judge anyway. All right. I will not require him to have a co-signer. And he's to take that 1-day anger awareness course. All
Thank
right, is there anything further from either party?
I'm sorry, can you repeat the bond for me?
It's 1,500 on each count, so for a total of a 3,000 SLB through pretrial, and he's gonna take the 1-day anger awareness course.
And are we doing the no contact?
Yes, he
as
can
well?
have no contact with either victim. He has to stay away from that location. He can return one time with a member of law enforcement to get any items that may be in his, that he may need to get from that location.
Thank you.
All right, best of luck to you, sir. Who do we have next?
Position 16, Philip.
All right, good afternoon, Mr. Phillip. Your case is 23 CR 003282G. You're charged with possession of use of drug-related objects, criminal trespass, and tampering with evidence with the offense date of May the 23rd. Do you understand your rights?
Yes.
Mr. Howard?
13 total. Last arrest was back in August. On Marta, possession of drug-related objects. That's open. He also got another open case for trespass and obstruction in the cab. Another trespass on probation in the cab for ag battery, ag assault. 2022 probation. 2021, he was arrested twice for probation violations. 2021 trespass. 2019 FTA, shoplifting NOLO, and a 2018 trespass.
Okay. Thank you. Ms. Bickerstaff?
Yes, this incident occurred yesterday at the Garnett Station, 235 Peachtree Street. And this is where Officer Perry observed the defendant sitting in the train station smoking a pipe. When the officer was placing the defendant under arrest, the defendant then crushed the pipe on the ground with his foot. The defendant currently has an active suspension with the Garrett Station, barring him from the station for 60 days. The state's recommendation is a $2,000 surety bond, $1,000 for criminal trespass, and $500 for tampering with evidence and the possession of a drug-related object. Also, to stay away from the Garrett Station at 235 Peachtree Street, as well as no alcohol, drugs, or weapons.
Mr. White?
Judge, based on the charges, we're asking that he be allowed to sign his own bond, $500 each count. Mr. Phillip has been homeless for 2 years. He has been struggling to come back from that, and he just recently got a job at UPS. He's been there a week. He's still in training. With a pay, I believe he said it was going to be $9.50 an hour. We'd ask him to be allowed to sign his own bond to give him some sort of chance to get a job and get off the street. There's no way that he can make any bond at this point. I have a problem with the possession and use of drug-related object charge, period. And the tampering with evidence. Was it evidence?
Your Honor, the warrant
There's an
states
argument.
that the
We're not gonna argue about that point. Okay. All right, defendant's gonna receive a $2,500 split bond as follows: $1,000 SOB through the jail, count 1, 500 surety, count 2, $1,000 SOB through the jail, count 3. He's stay away from that Garnett MARTA station as already required and have no alcohol, drugs, or weapons. Is there anything further?
nothing from the state.
I'm sorry, Judge. I missed. There was a breakup in the feed there for a second, and I missed the bond amounts.
Okay, 1,000 SOB, count 1 through the jail, 500 surety, count 2, 1,000 SOB through the jail, count 3.
Thank you, Judge.
All right.
Sorry about that.
All right, best of luck to you, sir. Who do we have next?
Position 3, Kane. You have a split bond.
All right, Mr. Kane. Yes, your case is 23 CR 003270E. You're charged with battery with the offense date of May the 23rd. Do you understand your rights?
Yes, ma'am.
All right.
Position 3 and position 4, they're co-defendants. I don't know if we want to do those back to back, but I did want to bring that to your attention.
Okay, thank you. All right, Mr. Hart, can I have that history?
Kane, 16 total. Last arrest was 2022, failed to appear. 2021 shoplifting, 2019, you failed to appear. 2018 and 17 parole violation, 2017 battery DV conviction, 2014 possession of 2 simple battery, shoplifting conviction, and a 2012 shoplifting conviction. That's it.
Thank you. Mr. Walker?
Yes, Your Honor. Law enforcement responded to a car crash upon speaking to the passenger, who was Mr. Kane. He advised that him and the driver, who is Mr. Campbell, also position 4, got into an argument while Mr. Campbell was driving. Mr. Kane stated that Mr. Campbell struck him, and in the adverse, Mr. Campbell stated that Mr. Kane struck him. They both had visible injuries, so they both were arrested. Based on the defendant's criminal history, we are asking for a $3,000 surety. No further contact with Mr. Campbell. That's all.
Okay. Ms. Wills?
Thank you, Judge. My client is 33 years old. He is originally from Georgia. He is currently employed by Avis Budget Group, where he transports cars. He's been employed there for only the past 3 weeks and is eager to get back to work. He will qualify for our representation and services. He does have 1 child, a 12-year-old son. He states that he and Mr. Campbell know each other. They're familiar with each other. They were in a relationship or have recently begun dating. They've known each other for 4 months. That it was just a verbal altercation that escalated. They both called law enforcement. However, Mr. Campbell was able to get through before my client was. He would like to have no further violent contact with Mr. Campbell. He does not believe that this incident will occur in the future, and we will request a signature on bond. If Your Honor is not so inclined, I would ask for a $1,000 surety. Mr. Kane states that he has recently suffered an injury, so he is only working part-time for the time being and is hoping to resolve that claim.
All right. Defendants that have $1,500 surety bond, he's to have no contact with the cross defendant and have no alcohol, drugs, or weapons as a condition. Anything further?
Nothing from the state.
All right, can we do Mr. Campbell?
Put your pants up, Campbell.
All right, Mr. Campbell, your case is 23 CR 003271E. You're charged with battery. Do you understand your rights? Is that a yes?
Yes, ma'am.
Thank you. All right, Mr. Howard.
11 total. 2014 and 17 probation, 2014 shoplifting conviction, 2011 and 12 probation, and a 2009 battery conviction.
And in Your Honor, this is a conflict case, and I believe Ms. McLeod may still be speaking with Mr.
Oh, Ms. McLeod is still on the phone.
Oh.
Okay. I forgot about that point. Okay, we'll have to come back to Mr. Campbell, but I will remember the history. I have it noted, and we'll come back at that time. But Ms. McLeod may still need to hear it. So, all right, can we go to another position?
Position A, Goshe.
All right, Mr. Goshe, your case is 23 CR 003275H. You're charged with theft by taking with the offense date of December the 4th, 2022. You understand your rights?
Yes.
All right, Mr. Howard.
His third arrest. Last arrest was 1971.
Okay, thank you. Mr. Walker.
Yes, in this case, the defendant took an Amazon package off of the victim's porch. It was captured on her Ring doorbell. We'll be asking for a $1,500 surety bond. Stay away from the incident location, which is 359 Lanier Street. No further contact with the victim, whose name is Jasmine Woodruff.
All right, is Ms. Woodruff present?
I don't believe so.
I don't think so. Okay, in light of the information before me, I'm inclined to give this defendant a signature bond through the jail. Ms. Wills, do you have any objection or anything you'd like to add?
No, Your Honor, I would just like to note that my client is 75 years old. He states that law enforcement did allow him to view the Ring video camera footage, and that the perpetrator ran from the residence. Again, my client is 75 years old. He has congestive heart failure, emphysema, and an oxygen tank. he can't run anywhere. So
I'm sure all of that will be taken up at a later date. Defendant will receive a $3,000 SLB through the jail. He's to have no contact with Miss Woodard, or is it Woodward? I'm sorry. And stay away Woodruff. I just wrote Wood. Sometimes the brain fills things in. He's to stay away from the address on Lanier Street. And I believe that will conclude all of his bond conditions at this time. Best of luck to you, Mr. Goshen. All right.
You said it was $1,000?
No, 3,000 SLB through the jail.
Thank you.
Thank you.
Position
All right.
12.
Okay.
Position what?
Position 12.
12.
Toya.
All right. Good
Like you
afternoon.
moving pretty good to me, PD Wells.
Okay. We're not gonna do that either. Mr. Montoya, your case is 23 CR 003278C. In this case, you're charged with simple battery with the offense date of October the 16th of 2022. You understand, right?
Yes, ma'am.
Mr. Howard?
31 total. Last arrest was 2015 bank robbery. He's on federal probation for that. 2009 simple battery, cruise in the third, hindering 911 call conviction. That's it.
Okay. Mr. Walker?
Yes, law enforcement was dispatched to a physical altercation. Upon arriving at the location, they spoke to a Ms. Tacavius Brandon. She advised that her and the defendant got into an argument that turned physical, at which time the defendant held her down and punched her repeatedly in the face. The state will be asking for a $3,000 surety, no further contact with the victim, Tacavius Brandon, and to stay away from the incident location, 634 Center Hill Ave.
Is Ms. Bradley on the Zoom conference, or is it and wish to make a statement? Hearing and seeing none, Ms. Wills.
thank you, Judge. My client is 45 years old. He has resided in the state of Georgia for the past 30 years. He is currently employed. He is the owner of CCM Contractors, and he also works with Top Rope Contractors, which is a business owned by his brother, where both companies do home renovations and tree removal. He has been a business owner for the past 2 years and worked with his brother for the past 3.5 years, and he will not qualify for our services. He has obtained a GED. He attended Atlanta area technical, where he received a forklift operator certificate, and went on to obtain a CDL in the past. He has a 15-year-old, 14-year-old, and a 2-year-old. There is no stay away that would be needed. My client states that the incident location is now an Airbnb. He was formerly married to the alleged victim in this case. He denies the allegations as alleged. He states that there was a DFACS investigation that was opened where his child was, well, this case and situation was investigated, and his child did recant and stated that Mr. Montoya did not put his hands on the alleged victim in this case. My client is a very large man. There were no marks or bruises noted on or about the complaining witness. And he has been in communication with his ex-wife since this time. This incident did happen back in October of 2022. And she has stated that she desired to dismiss the charges. My client states that he did confront the alleged victim about communicating with a male. However, he never was violent. He did ask his son to restrain his ex-wife because she became irate and upset, and he just wanted to pick up his things, gather his belongings, and leave the home. And that is when the complaining witness called police. So for those reasons, again, I would ask for a signature on bond, Your Honor. And if you're not so inclined, I would actually, I'm sorry. My client does not want a signature bond. I apologize. We would like a $1,000 surety bond. My client would like to bond out as soon as possible. He states he has a couple of engagements. And so he believes that having a signature bond may delay his process for being processed out of jail.
Okay. Defendant will receive a $1,500 surety bond. He's to have no contact with the alleged victim. And even though that address is alleged to be something else, we're still going to impose stay away, as I do not believe he has any reason to return there. Additionally, he's to have no drugs, alcohol, or weapons as a condition. Is there anything further?
No, Your Honor.
All right, best of luck to you. Have a good day. All right, who do we have next?
Is Ms. McLeod ready? I have position 4. Okay.
I am ready.
Position 4, Mr. Campbell.
Okay, and then we'll go to Mr. Mincy next. I have the history, but let's review it again for Ms. McLeod's benefit. Mr. Howard, very briefly, can I have the history for Mr. Campbell, position 4?
Very briefly. Let's see.
You all determined to give me a hard time today. Please give us the history.
11 total. Probation violations from 2014, 17, 2011, and 2012. 2014 shoplifting conviction and a 2009 battery conviction.
Okay, thank you. All right, Mr. Walker, I heard your arguments, but well, actually, I didn't. I heard the facts. I believe we know the facts, but let's repeat them just in case.
So law enforcement responded to a car crash. They spoke with the defendant, who advised that he was in an altercation with his passenger. They also spoke with the passenger, who advised that the driver, the defendant, Mr. Campbell, struck him first. They both had visible injuries, and at that time, they both were booked and charged with battery. Due to the defendant's criminal history, we are asking for a $3,000 surety bond and no further contact with Mr. Kane.
All right, Ms. McLeod.
Yes, Your Honor. My client is 41 years old. He is employed. He tells me that he has 2 different jobs that he works, and he's anxious to get out of jail. Your Honor, my client was the one who called the police because he had been assaulted by his passenger. As the prosecution has said, they both had visible injuries. But I do believe that my client would not have called the police had he been the aggressor, Your Honor. I know that my client does have some history, but his violent history is quite remote. I would ask the court to consider giving him a signature bond, given the fact that this is a dual arrest and that my client was the one who called the police. Nothing further, Your Honor.
All right, defendant's going to receive $1,000 surety bond. He's to have no contact with Mr. Kane. Additionally, have no drugs, alcohol, or weapons. Anything further?
I think the other witness's name was...
It's Kane. The cross defendant is Kane.
Yeah.
All right. Best of luck to you. Who do we have next?
Position 9, yes.
How much was that?
1,000. All right. Good afternoon, Mr. Guest. Your case is 23 CR 003276J. You're charged with criminal trespass with the offense date of May the 23rd. Do you understand your rights? Is that a yes?
No, yes. No,
All right. Thank you. Thank you, Mr. Howard.
5th arrest. Last arrest was last month for trespass. It's 23 CR 002323J. 2022 theft by taking, violation of family violence protective order conviction. That's it.
That was 2022, the family violence.
Yes.
Okay, thank you. Mr. Walker.
Yes, Your Honor. In this case, law enforcement was dispatched to 4255 Will Lee Road. The defendant was sleeping in a gym at that location. He was previously advised that he was not allowed to sleep in that location. And he had previously been criminal trespass. At this time, he was taken into custody. I'm just going to recommend $1,000 SOB. No, I'm sorry, $1,000 through pretrial services with a stay away from the incident location.
Okay. Because of the allegations, I'm inclined to give him a $1,000 SOB through the jail. Ms. Wills, any objection?
No, but my client would like me to know that.
Are you sure?
I know his hand is up, so I have to put it on the record.
I don't think we should know. Okay, go ahead very quickly.
I'm sorry, as quickly as I can. He states that he was only back there because the first time he was arrested for criminal trespass, he was not allowed to bring his belongings. And so he returned to gather his belongings. He has 2 backpacks that are still on the property that he believes are still on the property. He's been back there with law enforcement. I've advised him of his options.
Okay, thank you, Ms. Wills. $1,000 SOB to the jail. Don't go back to the gym. I understand that you may have things that are there. You've returned one time with law enforcement. I will allow another return with law enforcement one additional time to get any items from that from that gym. And then otherwise you are to stay away from that location and have no alcohol, drugs, or weapons as a condition. Anything further?
No, Your Honor.
All right, best of luck to you, Ms. Guest. What do we have next?
Position 1, belt.
Okay, Mr. Belk, your case is 23CR003268. In this case, you're charged with loitering and prowling and criminal trespass. Do you understand your rights?
Yes, ma'am, of course.
Oh, good. All right, Mr. Howard, can I have the history, please?
This is third arrest. Last arrest was 2022, 4 counts of forgery in the third, 2 counts of financial transaction card theft out of Gwinnett. That was April of 2022. July of 2022, they put him on probation for those charges. And he got a 2022 theft by taking dismissed.
Okay, thank you. Mr. Walker?
Yes, law enforcement was dispatched to 3213 Chattahoochee Circle in Roswell, Georgia, to the Grace Apartment Homes. The defendant was found living or asleep in a vacant apartment. Yeah, a vacant apartment in the apartment complex. The state has asked for $1,000 surety and no further or stay away from the incident location.
Okay, in light of the information before me, I'm inclined to give this defendant a $3,000 SOB through the jail. Ms. Wills, would you like to add anything additional to the record?
No, Your Honor.
All right, 1,500 on each count. Stay away from that location. Do not return to that entire complex, Mr. Belt. Additionally, you don't have no alcohol, drugs, or weapons. Don't even walk down that street, okay? Best of luck to you. Who do we have next?
What type of bond did he get?
$3,000.
Signature bond through the jail, 1,500 each count.
Thank you. Position 6,
All
Ella.
right, Mr. Allen, and this is McLeod's case, or this is the one he was holding for private counsel.
Oh, well,
I don't remember. Was this the gentleman holding for the private attorney?
Elam,
I think so.
Yes, yes.
I don't see his attorney on the line. Has anybody from the public defender's office spoken to him? Mr. Elam, your attorney is not currently present. Do you wish to have services of the public defender's office today? The public defender's office agrees to assist those who are currently incarcerated unless there's a conflict, and luckily we have a conflict attorney present as well. So would you
Judge,
like?
isn't Mr. Dixon his attorney?
No, no, his attorney is some other Hines name that we heard.
Katrina Hines.
And she's not present. Do you wish to have services of the public defender's office today?
Judge, we can't represent him if they've hired an attorney. If they tell us they've hired an attorney, we can't.
Well,
touch
I
it.
don't believe she has, as it
He has a
pertains to this
felony
case.
matter. so I
And there's
can't
no
speak.
entry of appearance of this attorney onto this case. So I don't know I don't know that she represents him for this matter.
But we
is
also
my-
don't know that she doesn't, and that's where the,
Okay, the only problem is either that or he goes forward unrepresented. And I don't believe that's ideal either, unless somebody's willing to try to give Ms. Hines a call. Is anybody willing to do that?
I would love to reach out in
I
between.
mean, if we had a number, I would definitely do that, Judge.
Okay.
Also, if you could give me just a minute, run this by a supervisor real quick, see what she has to say about it.
Okay, if that'd be great, but I do believe that because no entry may be entered for this particular case, she may not represent him for this. So, and I checked Odyssey myself, I don't see her name. So I believe he's unrepresented as it pertains to this case. But if you would like to go talk
The
to
freshness. Okay, I'll be right in a minute.
that's fine, thank you. Can we take another position?
And Your Honor, I'm sorry to interrupt. I have an urgent housekeeping matter that needs to be addressed.
Okay.
I don't know if the clerk's office can get on the line, but there was a Sean Domino. I have a case number that was accused 23CR 003273B. He should be on this calendar. Someone said that the case. I'm sorry.
I got an email about that one from the jail. Yeah. Shelley was CC'd on it. Let me read the email to you all.
I was told that the case was dismissed. Our office did not submit a null pros, so I don't know who else would have the power to dismiss a case.
It says, let me see. Greetings, Miss.
Excuse me, that case went to felony.
Did it?
So, Ms. Falk said that they're gonna send it to felony because of the way the warrant read. So she wasn't gonna file any accusations on it.
It's a C. Can it go to felony with a CR on it?
Oh, y'all created a CR case before?
I have a case number, so I'm just trying to, I just don't want anyone to be.
Yes, Mr. Domino, was it Marcus Domino?
Sean
or
Domino,
John Domino.
23 CR 003273B. I just want to make sure no one's missing their first appearance because it has a CR number, so I don't know.
What's his booking number?
Well, let's look it up. Can we do is Mr. Dixon's client there alone at the courtroom? Mr. Dixon has been very patient. Is that who's there? Let's continue to look this up and then come back to this.
And surprisingly, I think Mr. Dixon might have the easiest case on today's
He
calendar.
might. Mr. Dixon, are you present? Is this Mr. Dixon's client? Okay. Mr. Carr, your case. Okay. Mr. Carr, your 23 CR 003272A. I will not sound the charge in this particular case. However, the state has taken the position that they will speak about the facts of this case on a public record. I am going to direct the clerk's office to stop the live stream. The recording can continue.
And before that,
I know
happens,
the
the
state
state
will
would like to
object.
put on the record before we lose our record that we are objecting to the live stream being stopped. As you know, that serves as our record, and without it, we don't have one.
Well, the recording continues. The live stream stops. We